Chief Justice of India D.Y. Chandrachud has said that Article 35A of the Indian Constitution that was scrapped in 2019 took away fundamental rights. The CJI made these comments during the hearing of petition challenging the abrogation of J&K's special status. During the hearing on petitions challenging the abrogation of Article 370, the matter was raised to remove Article 35A. Chief Justice of India noted that 35A took away 3 fundamental rights. Let's in fact listen into what the Chief Justice of India said.
Volume 3, page 14. But you bring in Article 35A, which creates an exception in 3 areas. Employment under the state government, 2, acquisition of removable property, 3, settlement in the state, leave aside scholarships. So though Part 3 is made applicable, by the same vein, when you introduce Article 35A, you are taking away the 3 rights, 3 fundamental rights. 16(1), 19, 14, and 16(1). Then you are taking away the right to acquire removable property, which then was a fundamental right under 19(1)(f).
During the debate on Article 35A, Solicitor General of India Tushar Mehta argued that the article created an obstruction for the progress of J&K. He presented before the court that scrapping the article encouraged investment in the state, whose only other form of income was tourism and a few cottage industries.
Please look at the matter from the point of view of people of Jammu and Kashmir. Something which is impugned before your lordships is a constitutional exercise of power which confers fundamental rights, which applies the entire constitution, which brings the Jammu and Kashmir people at par with their rest of brothers and sisters, and Lord applies all laws which are welfare legislations, and I have the list which was not applicable to the state of Jammu and Kashmir. And the very unfortunate part is, and this is really a troubling part, that till now the people were convinced by those, my lord, who were supposed to guide them, that this is not a hindrance in your progress. This is your privilege. You fight. Nobody can take away 370 from you.
Ajay Chandel joins us for the very latest on this story. Ajay, what is to be read into the Chief Justice of India's observations while hearing this case? Okay, it seems that we've lost Ajay's connection there, but let me also bring in Amit Raina, Kashmiri Pandit, into the discussion. Amit Raina, what do you make of the way this case is panning out in court and the observations that were made yesterday by the Chief Justice of India, as well as the arguments put forth by the SG?
See, they are very similar to what we as an organization that Students in Kashmir has been saying for many years. In fact, we were also petitioners on abrogation of Article 35 in Supreme Court before it was abrogated by the government of India. And our petition was on a very similar line that Article 35A violates the basic fundamental rights of equality, of freedom to work and liberty. Because what has happened is, if you look at the way how this article was used to discriminate against the Indians living in Jammu and Kashmir, the people from West Pakistan who had become refugees in India post-partition and were given equal status in rest of India were denied even the basic rights in the state of Jammu and Kashmir using the same garb of Article 35A. And then the Valmiki Samaj, which was imported from Amritsar and Pathankot for sanitization work, they were given state subject only and if they continue to work sanitation workers. That means that their children had no right to upgrade themselves to move to a better life. Even if they went and did a PhD or a doctorate or became a great scientist, they still had to be a sanitation worker to enjoy the state subject benefits. So there was, again, for women. So if a man could marry from someone from outside, his wife was allowed to have equal rights. His wife by de facto became the state subject, but if women married someone from outside the state, forget her husband, even she lost her right as state subject. So there were a clear violation of 14, 19 in 35A, and Honorable Chief Justice was right saying that before freedom to fundamental right of property was taken away, the article itself violated that also. So yes, CGI has been right in his observation and in line with what many activists, including the Kashmiri Pandit organizations, have been saying for years, that Article 35A violates every basic tenet of Indian Constitution.
Right. Let me attempt to go back across to Ajay Jandial once now again. Now, Ajay, if you're able to hear me, the question I was trying to ask you earlier was on the observations made by the CJI and what bearing those will have on the entire case that, of course, is right now being taken up by the Supreme Court for hearing.
Well, see, Uday, it's very difficult to say that how it is going to impact the whole case as far as the hearing of Article 370 and the 35A is concerned. But yes, the comment of Chief Justice, is definitely important, as he said, as he clearly says that basically 35A was restricting the rights of the people of country. They were not able to, buy land, or they were not able to get jobs over here. So that is what he had said. So definitely it will take time to complete the proceeding, and then definitely they will be able to conclude it that what exactly has happened was right, or something need to be done as far as the abrogation of 370 and the 35 is concerned. But yes, his comment is very important, and how now the people, those who have filed the PIL, they see it and how they respond to that need to be seen.
Ashwini Bhatt, Kashmiri Pandit, also joins us at this point. Ashwini, this case, of course, has huge ramifications for Jammu and Kashmir, and also, of course, for the central government as a whole. Which way are you interpreting the hearing panning out?
Hi, good morning. No, I think whatever observations the CJI has made, till now, there's a regular hearing on this case. I think it's going in the right direction. Post India's independence and framing up the constitution, this seemed to be the last leg in terms of left for the entire unification of India in terms of the rights of equality for every citizen, barring whichever state or whichever region that citizen comes up from. Article 35A and 370 had huge, it was a roadblock towards the rights of equality for every citizen, whether that's from any other state. The rights that he or she has should be in unification or in its entirety for every single citizen of J&K as well. Why should a citizen of J&K have the right to own property or enjoy all the fundamental rights and not from any other state? So yeah, it's a welcome step, and it seems that it's going in the right direction, and we hope that the CJI puts a final nail into the abrogation and in letter and spirit the fundamental rights for every single citizen of India, irrespective of whichever state that he or she comes from, should be at par and equal.
All right, Ashwini Kumar Dubey, senior lawyer, also joins us now. Ashwini Kumar Dubey, now the Solicitor General of India has also made some very, very strong arguments during this hearing, while of course speaking about the progress of J&K that has been achieved by the abrogation, the investment that has come in, and also how the income modes, the revenue modes have shifted from tourism and a few cottage industries to much more after this decision was taken.
Yes, because the Article 35A, which was earlier, that was a discriminatory law. Discriminatory this Article 35A, and that was discriminatorily inserted in the Indian Constitution. And that was the reason all the development activities were confined to the particular community which was living there. By abrogating the Article 370 and 35A, now the new avenues have been opened. You see the G20 summit has happened there. People are visiting there. Yesterday, the Miss World visited and saw this is wonders of the world. We have not seen it earlier. This is Kashmir. Now, second part. The Article 370 of the which was implemented there, that was completely to appease a particular community. Now, by abrogating this, the Article 370, that has become the part of the country, and anyone can go there, he can buy the land, can do the business, can do that is the opening the new avenues for prosperity. And that is why, if you see, while the argument was going on, the Honorable Chief Justice of India-led bench was agreeing to the effect that Article 35A was discriminatory. And even today, if we see those who are defending Article 370 and 35A, they have agreed to the point that the constitution which was framed later on, that was exclusively for the people of Jammu and Kashmir, but there can't be two constitutions. And earlier, you remember, the same bench of the Supreme Court has said that the same constitution which has given right to implement Article 370, the same constitution, the same book has given right to abrogate it. And that is why the Constituent Assembly, which took decision in a higher side, if you see, the debates were going on, but few politicians were there which were in support of the Article 370 and 35A. Now, and the Constitution of India is supreme. Constitution of J&K is not supreme, because that is the legislative piece which was within the boundary of Jammu and Kashmir. But the Constitution of India is supreme, and rightly the Parliament, by exercising its power, have abrogated it. And that is why Article 35A was abrogated. People have started doing business there. People are getting domicile certificates. The discrimination toward the women have gone. Discrimination toward the Dalits have gone. Discrimination toward the OBC community has gone. Discrimination between the man and man, and one part of the man from one part and one from other part, Kashmir, that has gone. So now I think that by abrogating this Article 35 and 370, the center has did an excellent job. Yes, over to you.
Okay, let me take that back across to Mr. Raina as well. Mr. Raina, now, the fact, of course, is, as you were saying, that this, that the hearings are in line with your observations as well and your arguments as well in this particular case, and on this particular, on the objections raised to the abrogation of 35A and 370. But the fact, of course, very interestingly is that the SG has, of course, tried to make the arguments of the benefits of the entire state, not just the public or not just the permanent residents, but holistically, what all has changed for the entire state and now union territory since the decision was taken.
See, while the Honorable Court, before starting the hearing on 370, was very candid and clear that what they are only looking at the constitutionality of abrogation and nothing else, but it would be unfair for them to not see the changes that Jammu and Kashmir has seen post abrogation of Article 370, and every step that has been taken post abrogation of Article 370 has only ended up in welfare of the people of Jammu and Kashmir. First time in the state of Jammu and Kashmir, every resident, every citizen is equal. And I think it was the most critical point is that was the Constitution of Jammu and Kashmir and was Article 370 leading leading to discrimination against citizens, which was clear violation of the Constitution of India. Now, there are multiple instances one needs to remember. One was that the word secularism was missing, both in terms of spirit as well as a word in the Constitution of Jammu and Kashmir. And Harshdev Singh, who was at that point in time Panthers party leader and legislative assembly member, tried to bring a private member bill to add word secularism in spirit and in word, but he was denied by the then government, which I think was of PDP. So they said, we